Thank you, Ambassador. I, too, am an optimist at heart. Would like to be a bit more optimistic than I am. Find myself a little bit too pessimistic sometimes, these days especially. But looking for bright lights wherever we can find it. Okay, I'm going to talk about the appellate body crisis. I'm not going to, unfortunately, be able to solve it, but I'm going to hopefully try to paint a picture of what it is that's going on behind the scenes, what the issues are, and eventually, what may happen if this thing doesn't ultimately get resolved. Before I do that, though, I should alert everybody to not pay too much attention to what it is that I'm going to say, because I'm not a lawyer. I'm an economist. I'm married to a lawyer, and I frequently play a lawyer on our podcast, but I'm actually an economist and sort of a viewer of the system. But I think everybody here certainly understands how important the dispute settlement system is for the trading system at large, but also for U.S. agricultural interests especially. There's been a number of disputes over the 20-plus year history of the WTO that have been resolved. Most recently, we've got a wide range of cases, obviously, the two recent decisions on China for corn, wheat, and rice, looking at both domestic support within China, but then also kind of standard trade barriers, their tariff rate quotas. Not that long ago, we had the decisions against India for SPS measures, inhibiting American agricultural exports of a lot of food products, poultry, due to the avian influenza, sort of misapplication of science and scientific principles. So there's a wide range of issues that are covered under dispute settlement, or is what Joe referred to as the crown jewel of the system, that are now under threat. So the basic way of the way the system currently works is two stages, just to kind of set the stage here. The first stage is not what's under threat. This is the panel process, where there's a dispute between two countries. Say the United States, wants to challenge China's use of domestic support or these tariff rate quotas. So there's an initiation of what's called a panel, which is three ad hoc folks that get brought in on a particular case to look at that, and they're a combination of diplomats, lawyers. Once in a while, they'll have an economist that's actually brought in, but frequently they make us stay away from this. And they provide an initial assessment of what it is that's gone on in that particular case, an initial ruling. Both sides have the possibility of appealing that to the WTO's appellate body, which is the sitting body of 7 members, or supposed to be 7 that are there, any 3 of which are then appointed to that case to look at what the panel decided and to make an assessment of various questions of appeal that one side or both sides would have asked them to look into. There's supposed to be 7 of those. The problem is, for a couple of years now, the United States has been blocking the appointment of new members to the appellate body, and we're currently down to 3. You need to have 3 to be able to examine any given case. Right now, 2 of them are, one's an American, one's a Chinese. You're supposed to sort of recuse yourself in principle if you have conflicts. Obviously, there's a lot of U.S.-China disputes going on in Geneva that aren't necessarily going to allow for recusals. But by the end of this year, by the end of December 2019, 2 of the 3 are going to roll off, and we're going to be left with 1, which means that under the rules of the system, appeals aren't going to be allowed to even take place. So what that means is, after this initial panel decision that gets made, either party could essentially say, I want to appeal that case. They can lodge the appeal, but the appeal could then never be heard. And so these disputes then get sent into a kind of permanent state of limbo, and the dispute settlement system that we've been working with over the last 20-plus years no longer exists anymore, right? There's no formal ratification of these rulings, no authorization for retaliation or some other form of remedy in the system, and so the system just looks different. Okay, so that's why we're at this moment of crisis and why we need to deal with this right now. But I think the bigger question is, well, what's at the heart of this? And what I'm going to try to paint a picture of is not all of, or even most of the issues that the United States is raising. The Trump administration is holding up the appointment of these appellate body members, creating this sort of crisis. Not all of these are just Trump administration issues. So many of them are long-standing American concerns with the system, and so I think it's important to walk through those, because you can't just say, well, if we had a different U.S. trade representative, or well, if we had a different president, these issues would all just get resolved and they would go away. We may question the Trump administration's tactics in creating a crisis, but these have been, a number of which have been long simmering concerns for the United States. So the broad concerns, I'll put them into 3 buckets. What I'll call procedural, philosophical, and then the petty. And so I'll try to take them in that order. Petty, it's just like I couldn't find a better word. Procedural, these are the ones that are a little bit tricky but ultimately fixable. One is, so the appellate body technically gets 90 days to come up with a ruling in one of these cases. And what's become more and more difficult for them over time is to getting their job done within 90 days. And the 90 days includes, reviewing all of the initial ruling, getting together, making their decisions, and then ultimately getting it translated. These cases are increasingly complicated. Now with only 3 of the appellate body members, they have a huge pipeline of cases. You just can't complete them in 90 days. But the issue is, well, what if you can't complete it in 90 days, what is it that you do? And the procedure that they had taken upon themselves to actually extend and not make their decisions within 90 days, the members, including especially the United States, have said that doesn't work. That's not okay. Okay, so this is a legitimate problem, but this is one of these things that you could imagine designing some crafting of new rules by the members to fix this as an underlying problem. The second is, what do you do when one of the appellate body members is sitting on a case, but the case keeps going beyond the point in time in which their term ends and they're supposed to roll off? The natural thing to do is to just leave them on the case and let them, to complete that one to fruition. But some of the members' concerns, including the United States as well, what that can lead to is a situation where you might have, say, the European Union, which philosophically views the appellate body slightly differently than the Americans, having one member that's still sitting on the case that hasn't, on the appellate body that still hasn't rolled off yet because they're dealing with 1 or 2 cases that haven't yet been completed. And yet another European member has been added to the 7, so now we're at 8, but there's technically 2 Europeans that are sitting there, and that's somehow unfair, right? Because there's too many Europeans relative to Americans sitting at the appellate body at the same time. Again, a technical problem, but probably one that's eminently fixable if the members were willing to address it. The bigger question, though, is what do you do when the appellate body just gets decisions wrong? Wrong either, arguably wrong, or maybe politically wrong. They just cross some red line politically that they really shouldn't have done. And the concern is that under the current system, there really aren't any easy legislative fixes, right? We haven't been able to complete the Doha round, which perhaps would have implemented some of the reforms to the dispute settlement system. The committee structure that Ambassador Wolf talked about hasn't really been engaged to deal with this. And so there is a big question, right? We know in the United States system, sometimes, courts get things wrong. That's why we have Congress to rewrite laws to fix things when courts get things wrong, politically or just basic rules. We're lacking that function within the WTO, and that has meant that sometimes when decisions get made, these legal decisions get made that are either wrong, that all members would agree to be wrong, or that are just politically unsustainable, there's no way to fix them. There are potential ways to fix them, and there have been some proposals put out there, but the big question is whether they want to be engaged upon. Okay, so those are the main, I think, 3 procedural questions. Those are ultimately fixable if the members wanted to. But behind all of this, there's the bigger philosophical question is, what is the role of the WTO's appellate body? The way the United States historically views the appellate bodies, it sees it as a contract, and says that, the role of the appellate body is basically just to look at what the terms of the contract is, look at what the facts of this case is before it, and make a ruling of, whether the contract is violated in this particular case. So in such a world, there really isn't a role for stare decisis. That's one of these fancy legal terms that my wife tries to explain to me. Precedent getting set, right? These rulings, today's ruling on this particular issue doesn't have any implications for tomorrow's potential ruling on a very similar issue. It doesn't happen. It shouldn't happen in the American view. Whereas the Europeans tend to take a slightly different view of what the WTO and the appellate body in particular should be doing. They see it more as a court in interpreting these kinds of the texts as the cases come before them, and potentially establishing precedent for future cases, right? So there's an inherent conflict here philosophically about what the role of the WTO and the appellate body should actually be. And this is not new. This is a long-standing tension between especially the Americans and the Europeans philosophically. And this is a moment in time, right, in which this issue may be, hammered out one way or the other, and it potentially through the ending of the appellate body. Okay, so that's the sort of philosophical, but let me put it into the next bucket, the last bucket of petty, and this will sort of hopefully shed light on why this philosophical question can ultimately be important. And by petty, I mean the United States has lost some cases, right, that it would argue philosophically are because the WTO appellate body has relied too much on this issue of precedent and tried to be consistent with its rulings over time, as opposed to just looking at the facts in any one case that's brought before it and willing to overturn itself from an earlier case and admit that that earlier case maybe didn't make sense in light of the facts of this case. Okay. And why I say this is petty, because there's really just a handful of dispute issues in which the United States has lost that seem to be driving a lot of this debate from the American side. And they're largely in the realm of trade remedies, right? So this is anti-dumping, countervailing duties, anti-subsidy tariffs, the use of safeguards. There have been a couple of other cases, right, on tax. There have been some ag cases that we've lost on subsidies, though arguably we haven't changed much on some of those, right? If you think about Brazil and upland cotton, not much change there. There were just sort of transfers that were made to make that case go away. But in the realm of trade remedies, so we take anti-dumping, for example, the United States has lost dozens and dozens of cases, many of which are over the same exact issue. The issue of what's called zeroing, how you actually calculate an anti-dumping. This is a very technical thing. It's super boring. It's something that they do in the bowels of the Department of I think it's fascinating. I've written multiple papers about this, but most real-world people think that this is boring. But the fact of the matter is, the United States has lost more than 24 cases on this same exact issue and has been told now for over a decade that what it's doing in this process is wrong. But it really hasn't changed how it does it. And so country after country continues to bring cases after this, and this kind of leads to two sides of resentment. One by trading partners saying, how is it that you can continue to do this after being told time and time again that it's not okay? And the United States is forced to deal with this every time. Why do we need to keep being told that we're not allowed to do this? Right? And I think this is one of these arguments that especially Ambassador Lighthizer might view as something that the trading system is trying to get, or trading partners are trying to get through litigation, that they weren't able to get through negotiation back in the Uruguay round, right? And this is one of the key areas of conflict. I would say one of the procedural problems of the WTO is there's no way to fix this issue. We can agree, disagree about who's right and who's wrong, but the problem legislatively is there's no way to fix it. Even if we agree that this is some red line that the trading system just can't cross for the United States, it needs to allow the Americans to continue to do zeroing. The United States should give up something somewhere else through some sort of trade-off and bargain. There really isn't a well-defined procedure legislatively, even within the committee system, to make something like that happen. Right? So that's one example, zeroing. The use of safeguards, countervailing duties, this issue with China, whether Chinese state-owned enterprises can be viewed as are acting as what's called a public body. Chinese state-owned enterprises themselves, not the government, granting subsidies to other firms throughout the economy, whether it be state-owned banks or upstream firms that give cheap subsidized inputs to downstream firms. Right? These are the kinds of legal questions that the WTO has been forced to grapple with, and frequently that have come up with decisions that the Americans don't typically like. And again, the Americans that are typically fighting back against these things are the Washington, D.C. Trade Bar, the ones that also typically prosecute these anti-dumping and countervailing duties cases domestically within the United States. And so decisions that are getting made by the WTO kind of can hurt their business prospects here in the United States and in their other realm of what it is that they do. But the implications of all of this, of course, are that the trading system is now under threat. And it's under threat for everybody, including the benefits for the agricultural sector, for all the other sectors of the economy that aren't particularly reliant on access to trade remedies to keep their sectors afloat. And so when you look at the data, it doesn't make sense, and I spent far too much time looking at the data on these types of issues. These key concerns about trade remedies that seem to be driving the American position on this, they cover a tiny amount of American trade. It doesn't really make sense for the Americans to want to blow up the entire system just to try to, argue their particular griefs about decisions that they would have lost on anti-dumping, countervail, and safeguards. That being said, I'm not a diplomat, and that's where we are at the moment. So at the end of December, we are going to be likely confronted with a situation where the appellate body could end. I think the big concern at the moment is, the Trump administration, what they're doing on this particular issue with the appellate body follows much the same procedure as what they have done elsewhere on trade policy. If you look at the USMCA negotiations, you largely create a crisis. How do you do that? You impose tariffs on steel and aluminum on Canada and Mexico. You threaten to impose tariffs on automobiles that would really disrupt supply chains, and that sort of forces action and forces something to happen. You impose on China tariffs on $250 billion worth of imports, right? That forces a crisis, forces action. That's where we are also with the appellate body. I think the one giant concern that I have is the American side, while it's been critical of the existing system and been critical of a number of proposals that have been put forward by the Canadians, as Ambassador Wolf mentioned, the Europeans, to try to fix the dispute settlement system, all of those have essentially been pushed to the side and said, no, those are going in the wrong direction. So it's really unclear what it is that the Americans want here. They've made their grievances well known and well understood, but what they see as a solution to this issue is extremely unclear. And what it looks like is what they could really want is to just allow the current system to disappear. And if the current system disappears, then we're back somewhere like where we were in the 1980s, before the Uruguay round, before the WTO came into effect, where there was no appellate body, where in the 1980s, effectively any country could block the establishment of a panel, the dispute resolution process in the first place. You could just say, nah, I don't want to have that dispute on my national security tariffs, on my subsidies brought against me. I don't want anybody to judge on that issue. Or even if you were to allow the case to come forward, if you didn't like to have the ruling, you could block it at that stage. Obviously, that's not a rules-based dispute settlement system. And you end up in a world of power, where the big countries can basically say, I want you to do this, and if I say so and I threaten you with tariffs, you'll do it. That obviously sometimes can be beneficial for big, powerful countries, and it can prevent challenges to what it is that you're doing, but it also can affect or prevent the effective resolution of your grievances in other countries. So getting China to agree to scale back its domestic support on wheat and rice, or to get rid of its TRQs, or getting countries to better adhere to SPS measures and stuff going on with the OIE. That's going to be all of the progress, I think, that we have made over the last 20 years to kind of push the American scientific approach to thinking about trade, and especially agricultural and food types of products. What it looks like in a new world of dispute settlement, at least to me, is extraordinarily unclear. And then lastly, I think the bigger concern, what the dispute settlement system of the last 20 plus years, before last year at least, was able to do, was it was able to prevent every little mini trade spat between countries that had come up from escalating into tariff retaliation and little mini or bigger trade wars, right? And so the title of this conference is All of This Uncertainty, effectively, right? That's been introduced over the last year. The system is designed to prevent that kind of thing from happening. And the concern is, if we get rid of this system and we don't replace it with something that's equally effective, every little trade skirmish that starts out there, and there will always be trade skirmishes, right? We've all lived through this long enough to know that these things are never going to go away. We need a system to manage them. If we don't have a system of managing them, any of them could bubble up, become a much bigger deal than it needs to be, and put us back in this situation of uncertainty that we've all been living in for the last year plus, which isn't all that pleasant. In any case, thank you very much.